Well, thank you very much for the invitation to be here, and thank you especially for that kind introduction from David. I'm so happy. First of all, I'm honored and humbled by that introduction, but I'm also very happy to see him here. In fact, I told him that when I knew I was coming to Halifax, I wanted to call him to have breakfast with him until I found out I had the pleasure of spending the afternoon with him. So thank you. And thank you, John, for the invitation to be here. For those of you who had early registration and had earlier versions of the program, you will notice I'm not Chantal Bernier, who was our interim commissioner who could not be here today, but I am standing here in her stead representing the office, and I hope that I'll be able to give you an overview of our challenges at the office and answer any questions you may have. My trip to Halifax today was foreshadowed by a concert on the weekend at the NAC in Ottawa, where I had the fun of taking my husband out for a late Christmas present at an Ashley McIsaac concert. So we had our fill of Celtic music, and unfortunately I'm not nearly as entertaining, but if anyone wants to accompany me on a boombox, that might help. So today I want to discuss with you potentially turbulent zones where privacy and technology meet. Oh, sorry. There we go. And coming to this beautiful province brings to mind the analogy of waves colliding off your own cliffs on Cape Breton Island. And I would like to use that metaphor for the purposes of my talk today. But the technology would be the waves, ebbing and flowing in constant movement, and privacy principles would be the rocks, immutable, solid formations that stand as strong barriers between land and sea. But over time, even rocks begin to change shape ever so slightly and imperceptibly, a point that I'd like to come back to in my conclusion. So I'm going to highlight today 4 areas where we see technology and privacy meet, or rather collide, I should say. First, where increased technological capacity leads to increased surveillance. Second, where increased online crime begets demands for enhanced enforcement powers. Third, how living online invites a whole new host of conceptual privacy issues. And fourthly, how technological vulnerabilities increase risks of data breach. After expanding on the 4 areas where technology and privacy meet, my main message is going to be this. As rapidly changing information technologies bring about exciting new waves of innovation, so too do they wash ashore new privacy risks. While we must be flexible in adapting to this new reality, we must also stand strongly behind the immutable privacy principles that underlie Canadians' fundamental rights of autonomy, dignity, and integrity. So by way of introduction, let me begin by looking with you at how Canadians value their privacy. A public opinion survey that we commissioned last year found that 2/3 of Canadians are concerned or extremely concerned about the protection of their privacy. A majority, 56%, are not confident that they have enough information to know how new technologies even affect their personal privacy. 7 out of 10 think that their personal information is less protected than it was 10 years ago, while a slightly higher proportion, 71%, think that protecting personal information will be one of the most important issues facing this country in the next 10 years. Now, I should say that Canadians' privacy concerns may be even higher now, considering that the survey was carried out before the news that Employment and Social Development Canada had lost a hard drive containing personal information of some 583 recipients of Canadian student loans, and before Edward Snowden's revelations began shedding light on activities of the US National Security Agency and related actions by our own community security establishment here in Canada. Canadians' rising concerns about privacy are also apparent when looking at some of our office's statistics. So, for example, in the last calendar year, we accepted 426 complaints under Canada's federal private sector privacy law, called PIPEDA. That was up nearly 20% from the complaints received last year, the year before. And in the most recently concluded fiscal year, we accepted a record 2,273 complaints under the Privacy Act, which applies to federal government institutions, and granted more than 1,000 of those were related to the ESDC breach I mentioned a moment ago. But even accounting for them, the total would still stand at a record high of 1,114 complaints annually, which is 30% increase from last year. So rising privacy concerns among Canadians is apparent by the mere number of complaints that come in our door. Now, no doubt much of this heightened privacy concern stems from increased privacy risks Canadians see and feel as a result of emerging technologies all around us. Let me address the first technological wave that meets privacy, and that's increased technological capacity, which in turn increases surveillance by both public and private sector actors. Our society, enabled by technology, has reached a truly unprecedented level of surveillance capacity and dispersion of threat among the general population. Now, quite naturally, the agencies responsible for keeping us safe are highly motivated to embrace new surveillance technologies that can help in that regard, and we certainly can't fault them for that. The challenge is to integrate into these new public safety methods effective means of ensuring privacy protection, accountability, and oversight. Nothing has brought that closer to home than the recent Snowden revelations in the particularly vexing and secretive world of security intelligence. Our special report to Parliament of last January 28th seeks to contribute to the constructive debate on how we can effectively reinforce privacy protection, accountability, and oversight among Canada's intelligence community in an era of cyber surveillance. But there are countless other examples of increased public surveillance enabled by new technologies. In 2009, we reviewed a privacy impact assessment regarding the automated license plate recognition program, which is a joint initiative between the RCMP and British Columbia's Ministry of the Solicitor General. The program uses video cameras coupled with pattern recognition software mounted on police vehicles. These devices can read, record, and identify license plates and run them against databases holding information on suspended drivers, stolen, and uninsured vehicles. A match triggers further investigation and police intervention. In its first iteration, the privacy impact assessment we reviewed purported to collect both match and non-match information. In other words, even law-abiding car owners would have had their license plate numbers collected in a police database, albeit for a shorter period of time. So we challenged the RCMP, according to the analytical framework we use when evaluating the privacy implications of new government programs or initiatives. You can find this analytical framework described in a document entitled A Matter of Trust, Integrating Privacy and Public Safety in the 21st Century, which is available on our website. Now, you won't be surprised to hear that when pressed by our office, the RCMP was not able to demonstrate a legitimate need for collecting non-match information into their police database, and their systems were eventually reconfigured to exclude this information. In the end, the RCMP did proceed with ALPR, but in a manner that reconciled privacy and public safety. The ambit of the program was shown to be demonstrably necessary. The personal information collected was proportionate to what was necessary. License plate numbers were shown to be effective in assisting police investigations. There were no less intrusive alternatives to accomplish the goal. Safeguards were adopted to protect the information, and effective oversight mechanisms were in place to ensure compliance. So as a result, the RCMP was able to adopt surveillance technologies that enhanced its effectiveness while integrating privacy protection. But surveillance is not just the stuff of the state. A recent investigation we conducted in relation to a computer rental company will give you the jitters. In early 2012, we learned from the US Federal Trade Commission that they had just investigated a company using spyware application, including a camera covertly filming the computer users to trace missing rental laptop computers when they didn't come back on time. Since this company had franchises in Canada, our office initiated a complaint against the franchisee in order to investigate whether similar practices were being deployed here. And indeed, we found that the franchisee had activated the spyware at least 4 times in a week alone, collecting hundreds of pages of sensitive personal information. This included webcam photograph of a user along with email and home addresses, phone numbers, and personal messages to family members and friends. There were also screenshots of social networking site pages that included pictures of children. While theft prevention and asset protection are legitimate objectives for any business, we concluded that a reasonable person would not consider the use of spyware that covertly films users and records keystrokes as appropriate means for recovering lost or stolen laptops. The balance between business needs and level of privacy intrusion just wasn't there. The company accepted our findings and has stopped the practice. Still, the case illustrates the privacy risks that arise from the mere existence and availabilities of surveillance technology. Let me talk to you about a second area where technology and privacy collide, and that is increased online crime that seems to beget increased demand for online enforcement powers. Let's face it, as wonderful as it is, the internet has also become a haven for crime. Online crime, fraud, ID theft, or computer hacking as just some examples. Quite logically, increased online crime results in increased demands by law enforcement for enhanced investigative powers needed to combat it. Over the years, we've seen a slew of lawful access bills aimed at modernizing police investigative powers in order to keep pace with the emergence of online crime. None of these has yet come to pass for a number of reasons. Just some of the stuff not happening, David mentioned earlier. The most recent legislative initiative to enhance police powers needed to combat online crime is C-13, also known as the Anti-Cyberbullying Bill, following the tragic death of Rehtaeh Parsons, which you know only too well. Bill C-13 seeks to address a particular egregious situation when intimate images of an individual are shared online without their consent, making it a new crime deserving of criminal sanction. Now, on that count, we believe that the objective of Bill C-13 is a highly laudable one, particularly in light of the gravity of cases that have come to pass. But C-13 goes further. by purporting to address the general phenomenon of cybercrime. And while we recognize that crime on the internet must be met with powers on equal footing, we are currently examining several aspects of the bill and their potential privacy implications, including the appropriate threshold for the use of the proposed new investigative powers, the number of public officers who could use these significant new powers in an expanded scope of application, the provision that appears to grant immunity for parties disclosing personal information to authorities without consent, such as telcos, for instance, and the appropriate accountability and reporting mechanisms needed to shed light on the use of investigative powers. Now, the interim commissioner will no doubt provide her comments before Parliament when Bill C-13 reaches committee. And there she will present her recommendations on how the objectives of Bill C-13 may be achieved while integrating the appropriate level of privacy protection. Let me turn to a third area where technology collides with privacy, and that is living online, which creates new incentives for collecting, using, and tracking our online footprints. It also raises new conceptual issues, a whole new generation of conceptual issues. Is your personal information still personal once you've posted it? Is your navigation history personal even though it's connected to your computer rather than your name per se? These new generation questions about what constitutes personal information online are particularly relevant considering that Canadians are the heaviest users of the internet in the world, spending an average of 45 hours a week online. Living online does not mean an individual surrenders his or her right to privacy, and a couple of recent investigations remind us of this important principle. A Canadian activist complained to our office that officials of Aboriginal Affairs and Northern Development Canada and Justice Canada, two departments, had contravened the Privacy Act by repeatedly accessing and monitoring her online activities, and also distributing reports of her online postings widely within both departments. The departments acknowledged these actions, which began in February 2010, but contended that she had surrendered her right to privacy through her extensive online postings, and that the information being collected was relevant to ongoing litigation between the parties. Yet our investigation established that both departments were accessing and collecting personal information from the complainant's personal Facebook page that clearly extended well beyond what was directly related to a government operating program or activity in contravention of the Privacy Act. An individual's personal information, even when knowingly posted online, does not lose its character as personal information worthy of protection. On the private sector side, our office released its findings in an investigation of Google last month that further serves to remind us how privacy interests persist online. In this case, the complainant sensed he was being tracked from website to website after having looked up information about sleep apnea devices. On investigation, we found that indeed he was being tracked on the basis of personal health information, contrary to our office's guidelines on online behavioral advertising, and more importantly, contrary to Google's privacy policy, which reassures users that they will not be tracked on the basis of sensitive information, including health information. Even Google, in fact, was bamboozled, so to speak, in its technological monitoring of advertisers using its platform. We're talking about billions of ads, millions of advertisers making connections on the basis of website visits, some compliant, for instance, serving ads for cruises after visits to a cruise company's website, and some non-compliant, like making connections on the basis of visits to a website selling medical devices. Now, it's certainly not an excuse. After all, Google is technologically sophisticated to come up with the right monitoring mechanisms to ensure compliance, but it is telling of the complexity of the task. We made specific recommendations to Google that, to their credit, may accept it to implement. A user's online footprints, whether or not associated with a specific name, nonetheless constitute personal information in which an individual retains privacy interests. And those privacy interests will be even stronger when sensitive personal information is involved. Let me come to the fourth and last area I want to highlight today, where technology and privacy collide, and that's technological vulnerabilities that increase risk of privacy breach. With the advent of technology also comes the risk of compromising hundreds of thousands of individuals' personal information by merely dropping a tiny USB on a sidewalk or walking away with a small hard drive. And of course, someone breaking in to capture such information today no longer needs to be on site or even in the same hemisphere. The privacy risks from such technological vulnerabilities are exemplified in two recent cases, which are still unfolding and under investigation. On January 7th, 2013, Employment and Social Development Canada informed our office about the loss of an external hard drive containing the personal information of 583 Canada student loan borrowers and 250 departmental employees. The lost information included individuals' SIN numbers, name, birth dates, home addresses, telephone numbers, and loan balances. 4 days later, our office initiated a complaint against the department, and in the coming weeks we'll be reporting our findings, hopefully be able to share important lessons learned for both the public and private sector on the physical controls, asset controls, technological controls, and staff support needed to address technological vulnerabilities in relation to personal information. Let me turn to the private sector now. Just before the holidays, the giant retailer Target announced that malicious software had been used to steal the credit card information of more than 40 million accounts over a period of almost 3 weeks from point-of-sale terminals at its US stores. Then a month ago, a new twist. Target began emailing Canadians that their personal information may have been compromised, including Canadians who never shopped at Target. So our office is following up on these matters with the company as well. Let me just touch on some emerging technology and privacy issues that are still the subject of research and which we're following closely in our office. Let me talk a little bit about metadata. There are ever-increasing incentives in both the public and private sectors to collect so-called metadata, or data about the communications, such as the IP address or device location data. Since our special report to Parliament was tabled in January, new revelations alleging that the Communications Security Establishment Centre, or CSEC, captured Wi-Fi information at an airport in Canada. CSEC argues there was no interception of personal information because no communications content was collected, only metadata. A similar question regarding the privacy interests in metadata and whether it constitutes personal information has been put before the Supreme Court of Canada in the matter of the Spencer versus the Queen, a matter in which we've intervened. Our office has addressed this question from a technological standpoint in a research report that's available on our website called What an IP Address Can Reveal About You. Now, from a technological point of view, our research concludes that information about communication, such as the number or nature of websites visited, connected with an IP address, may be so revealing as to potentially disclose the identity of a person. But the challenge ahead of us is to get social consensus and legal clarity on the definition of personal information in this new technological reality. Another area that we are looking at is wearable computing. This is a technological development that puts privacy law to the test, and another one that puts privacy law to the test, and to many people it sounds like the stuff of Jetsons. But the fact is that both private and public sector are looking at the possibilities of wearing computers. Google has developed Google Glasses, and police services around the country are adopting or envisaging to adopt body-worn cameras namely cameras fixed to the police uniform. Our office has prepared a research report outlining the privacy implications of wearable computing devices in general, and we hope to make that available shortly on our website. Another emerging technology our office is looking at is facial recognition, which can positively identify individuals by the unique characteristics of one's face. Many fear that this innovation will bring an end to the barrier between one's online and offline worlds and render anonymity gone forever. While the reality is that the technology hasn't yet reached the level of sophistication, our office has significant concerns about the privacy implications of facial recognition as its uses can be employed by both the public and private sectors. On this too, we've recently completed a research paper that will be posted on our website if you want to find out more about it. Drones. Another privacy-sensitive emerging technology is that of unmanned aerial vehicles, UAVs or drones. Currently, their best known use in Canada is for search and rescue efforts or accident investigations, and we've been reassured that no drones are being used to collect personal information for law enforcement purposes yet. That being said, we know the technology is rapidly evolving, and we are following those developments closely. And at the risk of repeating myself, we have posted a research paper on that too, which you will find useful on our website if you wish to find out more. Now, although we have the capacity to conduct in-house research and technological analysis, we cannot do it at all, and we certainly can't do it alone. And I'd be remiss if I didn't mention at Dalhousie University the importance of our contribution program. The contribution program is a competitive, peer-reviewed, arm's-length program through which we fund cutting-edge research in privacy every year. And we invite the academic community to advance and disseminate new knowledge in these emerging areas. And we would like to see more applicants coming from the Atlantic provinces. So that's my pitch to you here at Dalhousie. To sum up, let me return to the image of the collision between technology and privacy like the roiling waters off Cape Breton Island. Some might contend that by sheer force, the waters erode rocks over time, and that in light of the inevitability of technology, privacy just doesn't matter anymore. But rocks are solid, and they do stand the test of time. While they may eventually change shape, they serve to remind us of the bedrock principles that Canadians hold on to dearly to define the kind of society we want to live in, one that embraces the advantages of technology, but in a well-balanced and socially responsible way that will be both enduring and beneficial for generations to come. So those are my formal remarks, but I'm happy to take questions if time permits. Thank you.
Absolutely. Thank you for that. As mentioned previously, we would welcome any questions, those who want to tweet them to the DDPD14 hashtag, or if there's anybody who wants to ask a question, if they want to just raise their hand and I will run to you with the microphone. If you just want to see me run, you can just raise your hand. There's one thing, Pat, one thing that I thought was very interesting was the interesting uptick in the number of complaints that the office has gotten over the last number of years, particularly and interesting to see the increase in complaints under the Privacy Act, which implicates the government as opposed to the private sector. What do you think are the driving forces, or what are the characteristics of those increased complaints, and what do they tell us about the privacy awareness or the privacy concerns of Canadians?
So we ask ourselves that question because resource-wise, we have to contend with an enormous increase in the number of complaints under the Privacy Act. What we can surmise generally is that the nature of the complaints coming in under both acts, but surprisingly more and more under the Privacy Act, is the increased sophisticated nature of the complaints, which we think in large measure is due to a heightened awareness of privacy issues disseminated through the media and elsewhere, where individual Canadians are, rightly so, raising issues and raising important questions about the personal information collected, used, and disclosed by the state about them. So I think that the complaints are increasing in numbers, but also increasing in the level of sophistication, which means much more technologically intensive effort on our part to get through the investigations. So.
Are you seeing any commensurate changes in the level of compliance and sophistication of, for example, the business community or even the government in dealing with privacy issues on a more routine and quotidian basis? And many of these seem to be kind of crises, something like the HRSDC or hard drive and the Target breach. But in terms of the more routine stuff, what are you seeing for trends there?
So actually that's interesting, because the more routine stuff is getting dealt with a little bit differently. So we've put a lot of effort into what we call early resolution. So we identify complaints through an early resolution mechanism or triage, where we think that a call to the organization and a call to the complainant can help resolve what are seemingly reconcilable differences. And that has been highlighted by the business community as being very appreciated, because before launching a great big investigation, it actually gives a chance to the organization to respond in a much more speedy way, and sometimes to answer questions that are clearly answerable and to the satisfaction of the complainant. We also have increased powers now under the Private Sector Act, not our Public Sector Act. As of a couple of years ago, we have increased powers to decline complaints or to discontinue complaints in the course of an investigation. So where we find that complaints have been adequately addressed by organizations or the government institution, or we found that this is raising the exact same issue that was raised by another complaint against the same organization, or where we find it may be more appropriately dealt with elsewhere because it's not really a privacy issue at its root, it's an employment matter or it's a litigation matter. We have a lot more flexibility under the Private Sector Act to triage these complaints. So that leaves us room and resources to really focus on the much bigger investigations that raise more systemic issues. And some of them involve massive breaches. And some of them are massive breaches sometimes through the doing of an organization that hasn't taken the appropriate safeguards and put them in place, but often it's really organizations that are duped by very determined external hackers, and no matter how reasonable the safeguards would be in place, the situation is such that their systems have been compromised. And so we work with the organizations oftentimes to try to sort out what's happened and to work with the organization in determining the best strategy to notify individuals. So that's the kind of evolution we're seeing on the private sector side. On the public sector side, as I said, the numbers are increasing, as is the technological sophistication of the issues being raised. We don't have the luxury on the public sector side to discontinue or decline complaints, so we have to take them all. But we are making a concerted effort anyway to focus more resources on the more egregious or systemic issues. Now, what will be interesting is, as some of you may know, the Treasury Board has announced that it will be, by way of directive, making breach notification mandatory on the public sector side, which is very interesting and will bring to light, I think, a lot of information that we currently don't have access to right now. And so we'll be in a position, I think, as will all Canadians, be in a better position to assess really the health of our information systems in government and the frequency of breaches and why they're happening. So I think that's a really positive development, and we look forward to that directive being put in place soon.
Is that going to involve notification to the Commissioner's office or to the individual or to both? And is it going to be similar to what was in the PIPEDA amendments that fell off the table?
So we don't know the exact wording or thresholds. What we understand so far is that there will be a dual reporting, both to Treasury Board, but also to our office. But what the thresholds will be and what the requirements will be, we're looking forward to working with Treasury Board or being informed or having some sort of discussions to work that through.